Perfect. Good morning. Welcome to this GreenS webinar on legal aspects of GPP. It's a pleasure to have Abby Semple from Procurement Analysis with us, talking about those aspects of legal concerns, legal opportunities, legal challenges, also in light of the recent publication of the European Commission Buying Green, third edition. And with further ado, I would say I hand over to you, Abby.
Thank you, Philip. Okay, I might say just a few words to introduce myself. I don't think I've met most of you, but look forward to hearing more about the GreenS project and your progress with GPP. My name is Abby Semple, and I've been working in the field of European regulated public procurement for 10 years now. And I specialised in sustainable public procurement beginning in around 2009 when I joined ICLE in Freiburg, and I worked there for a couple of years on a number of projects with them. I then came to London and started my own consultancy, Public Procurement Analysis, and through that I've had the opportunity to work with various public authorities in the UK, Ireland, and other parts of Europe, as well as a little bit internationally. And it's been really fascinating for me to have the chance to apply my knowledge of the law to practical situations where people are trying to improve their carbon footprint or to improve their management of resources through their public procurement. As Philip mentioned, the new edition of Buying Green was published by the European Commission a couple of months ago. I had the pleasure of working with Philip and other colleagues at ICLE to produce that guidance on behalf of the European Commission. And that really gave us the opportunity to look at what are the new rules under the 2014 procurement directives, what is possible, what has been made easier for public authorities in terms of green public procurement, and which areas are maybe, if not more difficult, at least perhaps more complex and require a bit of thought and a bit of explanation. So I hope to be able to cast some light on those areas for you today. I know that a webinar is not always the most interactive of situations in order to ask questions, but I encourage you to ask questions if you have any, to put up your hand to type in your question, or I think we'll have some time afterwards as well to do that. So I'd very much like to get your views, and if anything is unclear, please do let me know. Okay, so in terms of what I'm going to cover today, let me just get my slides up. So in terms of an overview, I'm going to give a little bit of a background on the new procurement directives, and then I'll go into the principles that underlie them. So these are coming from the Treaty on the European Union, talk a little bit about case law, and then I'm going to go into a more detailed discussion of what you can do at each stage of a procurement procedure in terms of green public procurement. So I expect most of you are involved in procurement procedures and have some knowledge of the basic structure and procedures. So what I'm going to focus on are the specific rules that apply at each stage where you want to include environmental considerations. And this is also very much the format of the Buying Green guidance. So if any of you have it in front of you, if you can download it easily from the EU GPP website, and a lot of the points I'm picking up on will also be covered in the Buying Green guidance. At the end, I'll talk a little bit about some of the specific traps or difficulties that I think we need to be aware of when we're doing green public procurement. And then, as I said, at the end, we should have some time for questions and discussions, hopefully. Okay, so the new procurement directives, which were adopted in 2014, they came into effect on the 18th of April this year. That was the latest date for implementation.
Abby,
yeah.
Sorry to interrupt. Could you share the slides with us, please? We do not see the slides.
Oh dear, okay. Hold on. Sorry, so the only slide I had shown was this overview slide. So I'm going to talk obviously about the background and apologies that you couldn't see these earlier. Okay, So yes, the new procurement directives, which were adopted in 2014 and which have come into effect this year, there are three of them, as most of you will probably be aware. There is a new directive which covers concessions, there's the directive that relates to the public sector, and then the one that relates to the utility sector. Now, in my presentation today, I'm going to focus on the public sector directive, the 2014-24 EU, and any references that I make to article numbers are articles in that directive. However, almost all of the provisions I refer to will also apply under the Utilities Directive. So if anybody who's listening is covered by that, for example, because you're providing energy networks, then be aware that the same rules apply in almost all cases to you. In general, the utilities have usually had a bit more flexibility regarding procedures and negotiation. But what you find is that under the 2014 directive, there's something of a convergence, so that the rules for the public sector and the utilities are now quite similar in most respects. Okay, so what did this revision process lead to? As it says on the slide, it took 3 years. Beginning in 2011, the Commission put forward a proposal for a new procurement directive. And there was a lot of discussion, a lot of debate between the Parliament, the Council and the Commission about the content of these directives. In the end, what we got were directives which have a broader scope of coverage. So there are changes in terms of concessions being regulated. In some cases, social services, there are slightly less strict rules than applied previously. We have changes to the time limits and procedures, changes in terms of publication requirements, so what you need to publish when you issue a notice for European level procurement. Also changes to the ability to reserve contracts, either for workshops, sheltered workshops, or programs which are employing, for example, disabled people or disadvantaged workers, and also what are called public service organizations, so a new ability to reserve contracts in those fields. Some very strong provisions in terms of electronic procurement, e-procurement, and making sure that tender procedures will be fully electronic by 2018. And then finally, the area that I'm going to focus on today, which is environmental and social criteria. In fact, I'll primarily be focusing on the environmental, but in some cases, the provisions apply to both, and it'll be clear as I go along where that is the case. Okay, so I always begin presentations on procurement, even for an audience which is quite knowledgeable, with speaking a bit about the principles, because to me, if you have an understanding of these principles, it really goes a long way to understanding the more detailed rules under the directive. So these come directly from the treaty, and they are, the reason they were developed by the court in particular, is to support the free movement of goods and services. Which is the fundamental principle of EU law. They are particularly relevant in the field of public procurement. So we have non-discrimination and equal treatment, and I've put in brackets there the definition given by the court of equal treatment. It's always worth noting that it's a two-part definition. So equal treatment doesn't just mean that you treat everybody in the same way. It also means that if two tenderers, for example, are in a different situation, for example, they don't have the same certifications or they don't have the same experience, then you should not treat them in the same way. So you should not give them the same marks, for example, under your award criteria. However, there is a saver at the end of that definition, which is that unless such treatment is objectively justified. So there may be cases in which you can justify derogating from equal treatment. Transparency in the procurement context, obviously we have to advertise our contracts if they're above a certain value. We also need to be extremely transparent about the criteria we're going to apply in awarding a contract, and also the weightings that will apply, and we're going to look a bit about how that affects GPP later on. At the end of a procedure, we obviously need to be transparent in terms of notifying all bidders about the outcome of the procedure and giving them information about why they were not successful if they failed. Proportionality is a very general principle. It has a lot of applications, not only in procurement, but throughout European law. And it is something that you need to keep in mind when you're setting GPP criteria. So is a measure appropriate to achieve its objectives, and does it go beyond what is needed? So for example, if your objective is to ensure proper management of a construction site, for example. You know, do you need to have an external auditor doing that, or is it sufficient that the contractor would have a certification in relation to how it manages its construction site? So you just need to consider measures, and are they going beyond what is needed in general for a contract? Finally, mutual recognition, which is a basic principle, which means that if somebody presents you with a certification or label which is equivalent to the one you've requested, and perhaps it comes from a different country or a different organization, you must also recognize it if it is in fact equivalent to the one that you've requested. And later on, I'm going to look in a bit more detail at how that affects the use of labels in GPP. Okay, I mentioned already the role of the European Court, which has been very active in the field of public procurement. So there have been over 400 cases decided by the European Court of Justice on public procurement. I'm just going to mention a few of them here because I think they give an idea of how the court's judgments have affected green public procurement. A case that was registered in 1989, the Storbelt case. So this concerns the building of a bridge between Denmark and Sweden. You can see a picture of the bridge there. And there were several points decided in this case, but the one I want to draw attention to is the requirement that where you state something as a mandatory condition in tender documentation. So, for example, you say the bridge must be so high or it must be made out of this material. You must then reject tenders which do not comply with that condition. And the reason for that, which the court brought forward in the case, is that there may have been economic operators, so companies out there, who decided not to tender for the contract because that mandatory condition was included. So it's only fair to them that you must also exclude anybody who does apply who doesn't meet the mandatory condition. This point was also confirmed in the more recent Nordicon case, which related to the building of a road and the type of asphalt that was used. And I think it's quite important to bear this in mind when you're deciding in terms of GPP criteria, whether you express them as mandatory conditions, that is technical specifications, or in some cases selection criteria, or you're expressing them as discretionary conditions, that is award criteria. And again, I'll go into the detail on the difference between those. Okay, the next case, which is probably the best known case in GPP, is the Concordia Bus Finland case. And this had to do with the city of Helsinki, which wanted to purchase environmentally friendly buses to operate its municipal transport system. They awarded a certain number of marks for the emissions of the buses. Specifically, they were concerned with nitrogen oxides. And the European Commission challenged this, and they put forward the argument that you know, perhaps all criteria in a procurement procedure should have to be economic in nature. But the Court of Justice very strongly rejected that argument. And what they said was that absolutely public authorities can include environmental criteria in their procurement procedures. However, they set down certain rules for how you can do that and the way in which you have to express award criteria. I'm going to talk about those rules later on. And just to note that one of them that we're going to look at in detail is the link to the subject matter requirement. Okay, moving on, a year or so later, the court had to decide a case which related to renewable electricity. So an Austrian authority had requested the supply of electricity from renewable sources. And one of the award criteria they applied related to the capacity of bidders to produce renewable energy. However, the way they assessed that criterion related to volumes of renewable energy which were in excess of their actual annual requirements. So they required a certain number of kilowatt hours per year, and they wanted a multiple of that. So let's say they required 100, they wanted their producers to be able to produce 200 kilowatt hours per year. Obviously, the volumes are not right, but just to give an example. The court in this case ruled that the award criterion was not legal because it was not linked to the subject matter of the contract. So they drew out a couple of points, which was that, you know, the volume was beyond what the contracting authority was actually buying, and also that they were not able to effectively verify the capacity of energy producers to produce this amount of renewable electricity at the time. Now, the argument of the contracting authority was that it needed to assess volumes beyond its immediate requirements due to the seasonal peaks and troughs. And that everyone knows that when you generate renewable electricity, you get sometimes you have a lot more than others, and that's one of the issues regarding you know, meeting our needs through renewable electricity. So the problem in this case was that the authority had just said the more renewable electricity you produce, the more marks you get under our award criteria. So the court wasn't actually saying you can't assess this or you can't assess a margin in excess of your needs. They were simply saying it's not fair, it's not proportionate, and it doesn't embody the principle of equal treatment to give more marks to any operator who produces the most renewable electricity. However, they also upheld the ability of the contracting authority to apply a weighting of 45%. So that was quite a high weighting, the award criteria, and the court said that was absolutely fine, they could do that. Okay. A more recent case, which was decided during the revision process for the procurement directives, is Commission against the Netherlands, also known as the Dutch Coffee or Max Havelaar case. So in this case, the court went into some detail on the use of social criteria in particular, but it also sort of confirmed its approach, which was that in award criteria, contracting authorities have quite a lot of leeway, quite a lot of flexibility in terms of how they define criteria. They do need to be adequately transparent. However, it did draw some distinction between what contracting authorities can do in technical specifications and what they can do in award criteria. And I'm going to look at those in a few moments. Okay, so the link to the subject matter requirement, which, as I said, is a fundamental requirement for conducting green public procurement. What does it mean? Where does it come from? So it was first mentioned by the court in the Concordia case, and this quote that I've put there expresses where it comes from. Now, I have some issues with this quote because I don't think the logic completely stands up. But nonetheless, I've written a paper on it. If anybody wants to read it, I can send it to them. But just to note that the court did consider this linked to subject matter a fundamental condition. And as I've already mentioned in the EDN and Weinstrom case, the court found that the criterion was not linked to the subject matter because there were no upper limits on the criterion and the contracting authority was not capable of verifying it. However, in the Dutch coffee case, they found that fair trade and organic criteria in terms of the ingredients for tea and coffee, which the authority was buying, they found that these were linked to the subject matter. So this is an interesting point because, for example, fair trade criteria, if you look at what is behind them, it generally relates to the practices of a producer or a small producer organization in terms of certification. It requires things such as long-term trading relationships between the purchasers of the tea and coffee and the producers. So what this suggests to me is that the court is willing to take a slightly more expansive view of what the link to the subject matter is. So it's not a very, very narrow view, which means that every criterion has to relate directly and very narrowly to what is being produced. It is possible to look at things such as fair trade, which by definition do not relate only to one contract. They have to cover a longer term period. And similarly for organic criteria, it doesn't make sense to say that a producer is going to produce one crop organic and the next crop not organic on the same field. So in some cases, when we start to look at environmental and social criteria, because of their nature, we have to take a slightly broader view, and it's very difficult to have a very narrow definition of the link to the subject matter. Okay, so going on, what we have in the 2014 directive is a definition of what the link to the subject matter means. and it appears in Article 67.3, which I've quoted there. And as I've suggested, I think it's quite an expansive definition in a way. So award criteria shall be considered linked to the subject matter of the public contract where they relate to the work, supplies, or services to be provided under that contract in any respect and at any stage of their life cycle. And then it gives examples in terms of the specific process of production, provision, or trading. And that reference to trading is explicitly a reference to the court's judgment in the Dutch coffee case, because that concerns fair trade. So it can be a production process, or it can also be any other stage of the life cycle. The part that I've put in italics there at the bottom do not form part of their material substance. So the picture on the right is a picture of St. Thomas Aquinas, who many of you may recognize. He wrote extensively about the doctrine of material substance. But in fact, this reference in the European directives is not a direct quote from St. Thomas Aquinas. But what it is an attempt to acknowledge the fact that when you buy renewable electricity or when you buy food from organic agriculture, you cannot tell in the final product that it has been produced in that way. So electricity is identical regardless of how it's produced. As is food, it's very difficult to tell, you know, from an apple, whether it's an organic apple or a non-organic apple. And this recognition, which is now written into the 2014 directive, allows us to apply environmental criteria which may not actually be discernible in the final product. Okay, so now we have an idea of what is linked to the subject matter. What is not linked to the subject matter in terms of public procurement? For this, we have to look to recital 97, and I should point out that the recitals to the directives are not in themselves legally binding. However, the court will have regard to them when it is interpreting the directive. So it is important to be aware of what is in the recitals, but just also to be aware that it does not have the same force, the same legal force as a binding provision which is written into the articles of the directive. So in recital 97, it states the condition of a link with the subject matter of the contract excludes criteria and conditions relating to general corporate policy, which cannot be considered as a factor characterizing the specific process of production or provision of the purchased work, supplies, or services. And it goes on to say, contracting authorities should hence not be allowed to require tenders to have a certain corporate, social, or environmental responsibility policy in place. So what this is getting at really is the concern which came out very much during the revision process, that companies were concerned that environmental policies would be used as a means of discrimination. So that you could effectively have an environmental requirement or a corporate social responsibility requirement, and that if it was too vague or too general, a company might be excluded from a tender procedure, even though it actually did perform well in terms of the specific environmental requirements of a procedure. So this is the balance which the new directives are trying to achieve. You can pursue environmental criteria as long as they're defined and they relate specifically to the contract. However, if you want to look at a general corporate policy, it's much more restrictive in terms of how you do that. Now, I am going to look a little bit at the whole area of selection criteria, where you can, for example, look at environmental management systems. However, in general, be aware that where a link to the subject matter is required, you should not be asking a company for their general corporate policy on environmental matters. The picture I'll explain. So this is the poster from the film, which some of you may have seen. But really, the relevance here is that it should not be the singer, not the song. So in this case, it is the song, not the singer, that we're looking at. So the song being what is actually being purchased for the contract, and not the singer in terms of their general practices. Okay, so what does this mean in terms of GPP specifically? Let's say you, as an organization, are buying catering services, and you want to take into account bidders' efforts to reduce their carbon footprint. So how would you go about doing this? I think the first question you have to ask yourself is, should it be part of the selection criteria, or specification, award criteria, or contract performance clauses? No, it may apply at more than one stage. So you might have selection criteria, award criteria and contract performance clauses, for example. But just to be aware that different rules apply at each stage, and we're going to go into some more detail on that. Secondly, you should ask yourself, is it linked to the subject matter of what you're buying? So is it specifically relevant to what you're purchasing under the contract? Then to do a general check in terms of principles, is it proportionate, transparent, non-discriminatory? It's also extremely important in the context of GPP to think about what type of evidence tenders are going to be able to submit and how you are going to go about verifying that evidence. This is something which is addressed in some detail in the Buying Green guidance, so I would invite you to touch upon it in this presentation in terms of evidence. Why is evidence so important? Well, as we all know, a lot of companies want to boost their reputation through claiming certain environmental features. Obviously do not stand up to scrutiny, and it's extremely important in public procurement that we're able to verify claims and to determine those which are true. Finally, I think it's very important to ask yourself what the effect of the criterion will actually be. Is it going to definitely result in environmental gains, or you know, does it in a tender we want you to provide a catering service which is resource efficient and environmentally friendly? Or do you also need to consider certain contractual incentives for the operator? You know, for example, to reduce their waste. Do they have a financial incentive to do that? You know, and how is that going to be applied in the context of the contract? Okay, so starting with the exclusion grounds, I'm going to go through now the different stages of the procurement process. So in terms of exclusion grounds, these are set out in Article 57 of the Public Sector Directive, and there are two types, those which are mandatory and those which are discretionary. However, you also need to consult your national implementing legislation in this area, because in some cases, member states make some of the discretionary grounds mandatory. So for example, compliance with the Article 18.2, which I'm going to look at, and this covers both environmental and social laws. Some member states may have made that mandatory to actually verify that at the exclusion, just the exclusion stage. I know, for example, that the UK has chosen not to do that. However, there are still other ways in which this compliance can be verified by contracting authorities. Other grounds which are relevant are grave professional misconduct in some cases. If a company has been dumping waste illegally, there may be evidence, there may even be a conviction, and in some cases you could use that to exclude them from the tender procedure. There's a new ground which relates to significant or persistent deficiencies under a previous contract. So this is where you might know, for example, that a company has been provided.
Yeah, Abby, can you still hear us? Yeah, we are losing you a bit.
Yes, okay. All right, so I'm going to talk in a moment about Article 18.2 a bit more, but just to be aware that these various grounds exist under the current directive, but you will need to consult your national transposition in order to see how they have been implemented. The part that's in italics at the bottom of the slide there is quite important, because there is a new provision under the 2014 directive relating to self-cleaning, which means that even if one of these grounds applies to an operator, they can demonstrate or attempt to demonstrate their reliability. Now, it is up to the contracting authority to determine whether or not they have done that. So it's not an absolute that, for example, if they have a conviction or they have violated a law, an environmental law, that they could write you a letter and then you would have to accept them. No, it's a case of they would have to demonstrate what they have done to address the default. So, for example, that they have submitted to an external audit, that they've replaced the people who are responsible for the problem, etc. However, even if they haven't done any of those things, there is still a maximum exclusion period of 3 years from the date of the relevant event. So it is relatively short, to be aware of that. Okay. In terms of Article 18.2, this is quite an important provision because it deals explicitly with environmental and social laws. And as you can see, it applies to any European Union law, national law, or collective agreement, as well as to certain environmental and social conventions that are listed in Annex 10. And I've picked out the relevant ones there that are listed in Annex 10. So I've put the word applicable in bold because it is still the case that you would have to show some sort of link between the violation of these environmental requirements and the contract that you're buying, or the contract services or goods that you're buying. However, if you demonstrate that they have not complied with the relevant environmental law, for example, you as a contracting authority can do one of 4 things. You can excuse them from the procedure, subject, as I already said, to the self-cleaning and time limits. And it's also possible that that exclusion will be made mandatory under national law. You can also reject a tender which does not comply. That's up to you as a contracting authority. If the tender is found to be abnormally low, so the value of the contract is disproportionately low, for example, because they're not abiding by all their environmental responsibilities, then you're also in a position to reject it. Finally, under Article 71 of the directive, there are new rules relating to the enforcement of these responsibilities in respect of subcontractors, which is very important because in a lot of public contracts, the subcontractors are carrying out the bulk of the work. So you are in a position to verify whether or not they have complied with their environmental responsibilities and also to require the replacement of a subcontractor who has not complied. Okay, selection criteria. I'm going to go relatively quickly through these because I know we're running a little bit short on time and I want to leave some time for questions as well. But just to be aware that the list of selection criteria is set out in Article 58. A lot of these will be relevant for GPP because this is an area where you can look at the general organizational responsibility and capacity. So, for example, you can ask them about if you're awarding a construction contract, you could ask them if they've previously carried out similar construction products that have similar environmental requirements, for example. That might be in terms of the type of materials they're using or the way they're managing resources on site, for example, what they're doing with the waste from the contract. Similarly, if it's a contract where there's going to be a lot of subcontracting, so for example, in an IT services contract, you might have that, IT equipment, you could ask them about their supply chain management systems. So do they really know whether the manufacturers are abiding by the environmental responsibilities of the contract and what systems do they have in place to verify that? In some cases, this will be part of an environmental management system, so EMAS or ISO 14001 are the most common ones. And there's more information in the Buying Green guidance about how you can apply these. And then you can also look specifically at the qualifications of staff. So again, in the service contracts, it may be the practices of the staff which are most relevant from an environmental perspective. Again, going back to the catering service contract I was talking about, you might want to know that staff are trained in how to reduce food waste, for example. And finally, you can look for samples of products or certificates regarding their quality, which may be relevant in terms of their environmental standards. Okay, moving into technical specifications. So we have the definition in Article 42, and just to note, this definition refers back to these concepts that I've already discussed regarding the material substance and the link to the subject matter of the contract, and also to the principle of proportionality. However, there is a specific provision in Article 42 which states that you can set required characteristics which relate to environmental and climate performance levels. So it's very clear that you can use technical specifications to address environmental concerns. As I already mentioned, examples of this would be if you want to specify organic food or electricity from renewable sources, However, it does need to be done affords equal access to tenders. So what that means is that it should not be overly restrictive, that it should be expressed in a way that any bidder could, in theory, meet that requirement. So I think everyone who is involved in procurement is familiar with the idea that you cannot require specific labels or specific brands in most cases unless there's an exceptional justification for that. And similarly, when we're using environmental specifications, we need to allow bidders to present different forms of evidence or equivalent standards which also meet our requirements. I've taken an example from the EU GPP criteria for furniture, and this requires that all plastic parts in excess of 50 grams should be marked for recycling according to a specific standard, an ISO standard, with the words or equivalent. So there may be other standards, for example, in China or elsewhere, which also meet the same requirements, and in that case, you would need to accept that as an equivalent. Okay, types of specifications. Just to be aware that that the one I just quoted from the furniture criteria is obviously an input-based specification because it's telling the bidders how they are to produce the products essentially that are going to be purchased. So they generally describe the materials used or the systems used to produce the product. However, there are other forms of specification possible, and in some cases, these may be very useful from an environmental perspective. Obviously, there's a link between GPP and innovative procurement because we expect new products to deliver higher levels of environmental performance normally. So in some cases, you may want to look for a performance-based or functional specification. And what that does is it describes the desired outcome rather than the inputs into the contract. So the example I've used on this slide relates to if you were building an office building, for example, you have various ways to achieve energy efficiency in that building, right? So you might, for example, say we want double glazed windows or triple glazed windows for insulation. However, you could also say, actually, what we want is an indoor temperature range of 18 to 20 degrees Celsius, and you could then assess the different options which bidders put forward in terms of how they achieve that, and you could compare the energy efficiency of those options, for example, through your award criteria. Typically, what you get in most big contracts is a hybrid specification. So you have some input-based elements, and you also have some performance-based elements. And this is particularly true in service contracts. So at the moment, I'm involved in a major fleet contract for a UK public authority, and there's the specification section is actually relatively short, but it does in some cases say, right, we need vehicles which meet these particular standards. But then it also gives an overall requirement in terms of fleet management, in terms of the environmental management of the contract. And what that does is it allows bidders to come forward with different solutions which meet your environmental and other requirements. The picture of the cat is not just a cute cat picture. It's meant to illustrate the concept that there are different ways to skin the cat. So there are different ways to achieve the same thing through procurement. I feel a bit sorry for that. Actually. Okay, variance. This is also part of technical specifications, and it's another way of giving yourself more flexibility in GPP. So, for example, you might say, right, we need to buy vehicles, and we think we're probably going to buy petrol or diesel vehicles, but we want to allow the market to propose other options, and then we will evaluate them, and if they meet our needs, then we will award that contract. So there are some requirements set out in Article 45 for how you do that. The first is that you have to indicate in the contract notice that you will accept variance and then state your minimum requirements. So in this case, if you're buying vehicles, your minimum requirements might be in terms of the range that they have, how far they can travel. You might have minimum requirements in terms of their emissions, their life cycle, their mileage, etc. Okay, and I've given an example there. It must be able to refuel or recharge within X number of minutes and have a range of X kilometers on a full tank or charge. What you do with your variant options then is you assess them against the same award criteria as the non-variant bids, and that allows you to determine the best overall solution. You can, if you want, require bidders to submit both a variant and non-variant solution. And the example there is, of forks and chopsticks. Obviously, they do the same thing, but they do them in very different ways. Okay, moving on to award criteria. Under the 2014 directive, all contracts must be awarded on the basis of most economically advantageous tender. MEET is the acronym in English. Obviously, I guess it's different in other languages. But just to note that even though you can no longer indicate in your contract notice that a contract is to be awarded on lowest price only, it is still possible, if you really want to only take cost factors into account. However, obviously from a GPP perspective, this is very seldom going to be what you want to do. In general, you would want to include at least 10 or 15% of your marks to address environmental issues in your award criteria. Now, there are some exceptions to this. If you're buying products which are quite standardized, you may feel that you can address all of your environmental requirements in your technical specifications alone. However, I think given that the market is constantly changing and innovating, it is a good idea to include award criteria relating to GPP wherever you can. You then have a choice in terms of what criteria you apply, and you have quite a lot of flexibility in terms of how you define your award criteria. You can obviously take environmental considerations into account, as was determined in the Concordia case. You can also, in your cost criteria, apply life cycle costing, which can also include costs for environmental externalities. So that is another way of addressing environmental concerns in your award criteria. Okay, just the rules on award criteria, we've touched on some of them already. You have the link to the subject matter requirement. They must not confer an unrestricted freedom of choice on the contracting authority. So what that means is they must actually allow you to distinguish between bids, and they must be accompanied by verification provisions as well, because otherwise you could be making an arbitrary decision, and how can you ensure that that's actually a fair decision if you haven't got verification provisions. They must also ensure the possibility of effective competition, the third point there. That's interesting because in the Concordia case, the court actually said that the fact that only one operator on the market could meet a specific environmental requirement did not in itself invalidate the award criteria. However, I think it's key to note the possibility, the use of the word possibility there, because if it's impossible for any other operator to meet a criterion, then it probably is discriminatory. So what they said in the Concordia case was that, okay, in practice, only one operator put forward a solution which got full marks. However, it would have been possible for other operators to put forward these solutions if they had chosen to. And I think that's a key question to ask yourself when you're setting your award criteria. The part in green at the bottom is also quite important, I think, because you should never have an award criterion which relates to, for example, compliance with specifications. It should always relate to performance above and beyond your minimum requirements. And you are required to set a weighting for those award criteria. There are different approaches to weighting. In general, you must always identify them in advance and do think about what the effect is going to be as a whole in terms of you might have your 10 or 15% of marks for environmental performance, but how does that compare to the other criteria and how are you going to assess them? Just an example here of why I think weighting is so important. You have to make sure that you're using the full range of marks. So, for example, in a tender for IT equipment, you might say we have 15% of the marks for environmental performance, and you then want to make sure that it's possible for bidders, or it's likely that bidders will score everything between 0 and 15. So you might have in your specification Energy Star, right? The IT equipment has to meet the Energy Star requirements. If a tender just meets that, so it only offers you Energy Star and nothing more, it should get 0 of the marks in terms of environmental performance, because it hasn't offered you anything above and beyond your specification. However, if it goes beyond in some way, so for example, it offers a take-back scheme or recycled materials, you could give it something higher. And then if it offers all of those, plus also gives you energy efficiency levels which are beyond Energy Star, then you might want to award it the full 15 marks. The reason why this is so important is because if you say, right, we have 15% of the marks for environmental performance, but every tender which has Energy Star will get at least 10 of the 15 marks. You're not actually using all of your marks, and you're distorting the weighting vis-a-vis the other criteria, such as cost. And so I think it's as much, so people sometimes focus on, okay, should we give 10%, 15%, 5%, 20% to environmental criteria? As important as that question is, how are you going to actually score tenders against those? And are you going to use the full range of marks available to distinguish between bids? Life cycle costing, I'm not going to go into too much detail, but just to be aware that there are rules set out in Article 68 in terms of how you can do it. It is fairly comprehensive in terms of what you can cover. So the second point there, you can also cover environmental externalities. And life cycle costing is obviously an extremely important area in terms of making the economic case for GPP, in terms of looking at what the true costs of a contract are. There are certain transparency requirements on life cycle costing, so you need to indicate what method you're going to use, and there are certain rules about how that method is defined. Essentially, this is to avoid life cycle costing being used in a discriminatory way. But there's also a requirement that the data required has to be obtainable with a reasonable effort by normally diligent economic operators, including operators from third countries. So you do have to be careful that when you're requesting data from economic operators, that it's realistic for them to provide this. There's a note in the directive that there's a common EU methodology for LCC developed, you must apply this. At the moment, this only exists in relation to vehicles and the Clean Vehicles Directive. And if you look at the annex to that Clean Vehicles Directive, it gives you the actual monetary assumptions that you would make in order to apply life cycle costing to vehicles. Okay, so you've asked your bidders for these various elements within the tender. How then are you going to check what they're doing? How are you going to verify their claims? The general principle, again, goes back to equal treatment and transparency. So if you're going to accept or reject evidence from one bidder, you should apply the same approach in relation to others, unless they are in objectively a different situation. So, for example, you might say that a bidder who is in a different country, they wouldn't necessarily have the exact same evidence, but you would want to apply the same approach based on their particular situation. You do need to follow whatever rules you have stated in your procurement documents, and going back again to the Storebelt and Nordicon cases, be very careful about including mandatory conditions. So, for example, if you say all bidders must submit the following certificate, it would be very difficult then to admit a bidder who did not submit that certificate, even if they had a very good reason why they didn't submit it. So just be careful if you're going to express things in mandatory terms. It's usually better to say the contracting authority reserves the right to reject tenderers who do not submit the certificate, just to give yourself a little bit more flexibility in terms of what situation you find yourself in. For exclusion and selection criteria, there is a full list in the directive of what you can ask for, so you need to refer to that when you're requesting evidence. There's also something called the European Single Procurement Document, which bidders can submit as preliminary evidence that they comply with the criteria. You can look behind it ultimately for the evidence, but in the first case, they need to be able to submit it as a sort of the first step of demonstrating their compliance. It's often the case that bidders will form into a consortium or a grouping to tender for contracts, and in that case, you need to verify that all of the members on whom they are relying for that aspect of the contract meet the relevant criteria. So, for example, in a construction contract, if a particular subcontractor is responsible for site management of the actual construction site, then you would need to verify that they comply with relevant environmental laws, not just the main contractor who is tendering. So you do need to extend those requirements down the supply chain. In award criteria, you have a bit more flexibility in terms of the type of evidence that you ask for. However, as mentioned, you need to apply equal treatment and transparency. If you're requesting labels or test reports, there are more detailed rules that apply to those. I'm going to go into those now. Okay, so environmental labels, this is an area many of you will be familiar with, and they can be used at all stages of procurement. So you might request a label in your technical specifications, or it may be award criteria or contract clauses. I've put some pictures of the most common labels there that you may see. I would really refer you to the Buying Green guidance on this, because we spent quite a lot of time trying to interpret the provisions that are in the directive and give people advice on how to apply them, because unfortunately the text of the directive is not very clear in terms of what you can and can't do with labels. But I've tried to summarize the rules here, and again, they'll look familiar to you because they relate very closely to the rules on award criteria. In general, the principle is that you cannot require a specific label. So you could not say, for example, you must have the EU Eco label, but you can require a third-party certification. So you could say you must have the EU Eco label or an equivalent label which meets the following requirements. You do generally need to look at the specific criteria underlying a label rather than just referring to the label itself. And there are two reasons for that. The first reason is to ensure that all of the criteria are in fact relevant to your contract. So for example, if you are asking for the EU Eco label for paper, for example, you need to ensure that each of the criteria in there is actually relevant and that products available on the market meet those criteria. Secondly, you need to do it for transparency reasons so that bidders can see straight away what the requirements are that they need to meet. Okay, similar rules apply to test reports and certificates. These are maybe not used quite as commonly, but in certain areas you will need to ask for a test report, for example, from the manufacturer. And the rules are almost identical to those for labels. Okay, the final topic I want to touch on is contract performance clauses. So traditionally, the European procurement directives have not regulated contract performance clauses in very much detail. So it is an area where you have quite a lot of flexibility. Just to be aware that the link to the subject matter requirement does apply, and you need to mention them explicitly in your procurement document. Sorry, just one moment, I'm just going to check I'm still on. Hi.
Abby, are you still with us?
Yes. When did it cut out?
Never really cut out. We just see you maneuvering on the screen.
Ah, okay. So I'm in now. I'll go back to the slides. Yes.
Yes. Mm-hmm.
Okay. Sorry about that. I don't know what's happening, but so yes, I was just I'm going to finish off quite soon, but just wanted to touch. Okay. I think I might be in it twice, actually. Hold on a second.
Yes, you are that twice. I just kick you out one.
Yes, can you do that?
It's done.
Thank you. Okay, that's good. I can't hear my own voice now.
Good, perfect. Contract performance clauses, the slide is on.
Yeah. But it won't let me go to. Okay. Okay. So yes, there's an explicit provision which allows you to address environmental considerations in your contract performance clauses. They do need to be, again, linked to the subject matter of the contract, so you're not looking for general corporate policies in your contract performance clauses. Just to be aware that there are rules in the new directive on modifications to contracts. You need to be aware of that as well. They're set out in Article 72. In terms of GPP, there are a number of ways in which you might want to use your contract clauses. The most obvious is to enforce bid commitments. So if somebody has offered to sell you equipment that meets a particular environmental standard, whether it's Energy Star or something else, that should be included explicitly in the contract. The most common way of doing that would be to include the specification or the tender document as an appendix to the contract itself. However, you may also want to go further and allow for monitoring or penalties or incentives linked to environmental matters. As I mentioned, for example, in a catering contract, you might have incentives linked to the reduction of food waste. And finally, you want to use your contract to encourage continuous improvement wherever you can on behalf of your bidders. So a lot of public sector contracts are long-term. They require essentially a partnership approach between the contracting authority and the contractor. So you want to, wherever possible, use that as a constructive basis for improving their environmental performance. And I've given there the example there in relation to food waste. I think anybody who's been involved in contract management will know that it's seldom a self-fulfilling prophecy, the contract clause. You do need to have active management of most contracts. And in particular, in my experience, it's down to good working relationships between the client and contractor to ensure that these contract provisions actually become reality. Okay, just a brief note on some of the recommendations and in particular issues that sometimes trip people up in GPP. So I think it's very important to do a sense check on your GPP criteria, whether they come from the EU criteria or national sets or elsewhere, just to ensure that they will be interpreted in the same way by all bidders. A good way of doing this is to have a pre-procurement engagement session and to actually discuss your GPP criteria with bidders or to send out a draft version for them to comment on. In relation to selection criteria and technical specifications, you do need to make sure that they're in strict conformity with the rules and the directives. Award criteria, you can be a little bit more creative. You can think a bit more about how they're actually going to meet your individual needs. However, you do need to think carefully about the whole issue of weightings and scorings, as discussed. And finally, to look at the life cycle costing elements, how you could use those. In terms of verification, again, it's a balance. You want provisions which are robust, but they shouldn't be too restrictive. So you don't want to close off the market through your verification provisions. And finally, your contract performance clauses should really be there to reinforce the commitment and to encourage innovation from your suppliers. Okay, in terms of the guidance that's out there, obviously the Buying Green guidance is probably the first source to look at. The Procure Plus manual, Philip, I don't know if, I think there's a new edition of that available now, is there, online?
In autumn, yeah. In
the autumn, okay, so soon we'll have a new version of that available. And then this website, which is maintained by ICLAI, the Sustainable Procurement Resource Database, is very good in terms of looking for examples, tools, criteria, and I've put a couple of other websites there which are quite useful for this whole area. Okay, that's it from me. Thank you, and sorry about the sound difficulties.
Thank you very much, Abby, for this really great and sharp overview on all the legal aspects of GPP. I just want to open the floor to you now to raise any questions. You have next to your name a hand symbol, so you can raise your hand. Actually, I'm just waiting for the first questions to come in. So we have our first question coming in from Alenka Buya. Please introduce yourself before I give the floor to you, Alenka.
Thank you. My name is Alenka Buya, coming from Slovenia. Hi, Abby.
Hi, Alenka.
Well, I have one question that really bothers me quite some time. I noticed that a lot of purchasers, so public authorities, when publishing GPP tender, they do not define the subject matter in a way that it tells you immediately that you are doing green tender.
Mm-hmm.
And it's really, because when you go down, then you see, of course, there are technical specifications and all other stuff. What about, and you mentioned also many times, link with subject matter. So what about this? If, I would say, is it mandatory to describe what you purchase in subject matter as green or not?
Thank you for the question, Alenka. In my view, and I suppose I can only really give my opinion, but I don't think it's mandatory. I think it can be extremely helpful, but in the cases where the court has applied the link to the subject matter test, essentially what it's done it has said, okay, well, what is the authority actually buying? You know, so it's buying electricity in the following quantity. So provided that the link is there between the environmental requirements and the quantity and nature of what it's buying, the court would accept that the link was there in principle. In terms of the sort of strategy or, you know, ensuring that GPP is successful, I think you're absolutely right. But in most tenders, it is a good idea to draw attention in the title of the contract even, or certainly in the short description that appears in the contract notice to the inclusion of environmental evidence. I suppose there might be two exceptions to that. One would be perhaps in jurisdictions where GPP is already so well established that you can almost assume that if an authority is buying vehicles or electricity, that there will be some environmental element. I don't know whether any jurisdictions like that currently exist in Europe, but maybe some of them are getting there. And the second might be where you have political considerations which make it very difficult for procurers to apply GPP. And I've worked with certain contracting authorities who are in this situation. And even though they know that they must and they should apply environmental criteria, they almost don't want to draw too much attention to it for fear of being forced by colleagues to remove it. So in some cases, I think it's quite difficult, but I accept that it's usually a good idea.
Okay, thank you. Can I ask another question, or is there somebody else? Because I don't know.
Okay, please go ahead.
Yeah, it's okay. You mentioned reducing carbon footprint, and then you were talking about service, so catering service.
Mm-hmm.
But what in the case of purchase of food? And you want, from the supplier, you also want to make requirement to reduce his carbon footprint.
Mm-hmm.
Is the best way to put these requirements in the contract performance clause?
To me, I think something like that, if it's going to be in the contract performance clauses, you need to draw attention to it. Because traditionally, there's been a situation where, at times, the European Commission has encouraged authorities, more so actually with social requirements, that they should put them in the contract performance clauses. And the issue I have with that is that if you haven't actually evaluated it during your tender procedure, how can you be certain that the contractor actually has the capacity to make those commitments a reality? So, absolutely, I think it should be in the contract performance clauses, but I wonder whether it's enough for it only to be in there, whether you shouldn't also have it either in your technical specifications or in your award criteria. Now, you do need to be a bit careful with carbon footprint, because obviously people think about, okay, based on the location, where the food is being brought from, is it going to be discriminatory? And all I can really say about that is that it has not been tested by the European Court. So, if you were to, people talk about food miles, for example, and I think the one thing that you need to be aware of is that carbon footprint is going to be more than just food miles. It's going to have to do with the means of production as well, as I'm sure you know, Alenka. So there's no case law that says you cannot look at carbon footprint or you cannot look at food miles even, but I think you would have to apply the general principles. So is it proportionate? Is it actually achieving what you're trying to achieve, which is the reduction of the environmental impact of food production? And is it applied in the same way to people who are in the same situation, or is it fundamentally discriminatory?
Yeah, this is very tricky.
Yeah.
Because they are talking a lot about distance, food miles, also shorting this supply chain and things like that. So it's a lot of activities here, but they are very tricky, huh?
Yeah, not easy.
Okay, my last question is about national transposition.
Okay.
Because of course member states are transposing these requirements from directive as to their suitable needs. So this, does it mean actually that this will be not, or this could be some treat to equal market or single market, or because obviously there will be no overview how this transposition went to the countries, no?
Well, I think the first point to note is that the vast majority of provisions in the 2014 directives are mandatory for all member states to implement. So there are only certain areas where they can make choices about how to implement. And I mentioned, the exclusion criteria, for example, that they can make some of the discretionary criteria mandatory if they choose. There is a process of notifying the national implementation to the European Commission, and in cases, certainly with the 2004 directives, in some cases the Commission will challenge a member state if they feel the transposition doesn't fully reflect the content of the directive. I'm not aware of any proceedings that have been launched so far in respect of the 2014 directive. But yes, I mean, public procurement, I suppose, is not an area of full harmonization under European law. So, for example, procedures under the European thresholds are not subject to the directives. And within the directives, there are certain areas where it is left up either to the member state contracting authority to make decisions. But I think one thing that is worth noting is that the treaty principles will apply to all contract procedures, provided there's some element of cross-border interest. So you might not be subject to the full detailed rules, but that doesn't mean that you can ignore European law altogether.
Yeah, perfect. Oh, you just remind me on another question, because I don't recall what it's written in directive. Is there any threshold regarding GPP?
Not a separate threshold. No, it's the same threshold as applies to all contracts. So it's in terms of the it's the same. Yeah.
Yeah, because in some national levels there are some thresholds. They have been. I don't know now. Okay.
Right. Okay. Yeah.
Thanks a lot, Abby.
Not at all. No.
Thanks to you too for the questions and also the answers. I just want to open to the floor to all of you again. Just if you have a question, raise your hand, please. Okay, we got one question from Evita. Could you please introduce yourself and then go ahead?
Hello.
Hello, do you hear me?
Yes.
Hello. Yes, I have one question about you. Abby have mentioned procurement principles as such. Do you have in mind what are Green Public Procurement principles?
Thank you, Evita. Yes, I suppose, I mean, you could say that the same principles apply, but also I think the principle that I think is most important in terms of green public procurement is the principle of effectiveness, which is not something you find written in the procurement directive. But to me, if we're going to spend time, putting environmental criteria in tenders, evaluating them, it is a lot of work. It's a lot of work on everyone's part, both for the public authority and for the bidders. And we need to have some indication that these are being effective, that they're achieving what we want them to achieve. So I think that's something which is, a lot of authorities have been doing green public procurement for a long time, but not that many of them can really say what the overall impact is. And I think there's beginning to be more focus on that. And you can say that it ties in as well to the principle of proportionality, because, while there may be many things that we can achieve through GPP, we can't achieve everything. So we need to make sure that the effort that we're extending on GPP is, to me, that it's going to the areas where we really can make a difference, and that the market understands that, that there's an understanding that this isn't just being done for the sake of it, but that it's actually having a tangible effect. And
thank you very much, Abby, for this. So thanks for referring to that it needs an impact. This needs to be measured when we come to a range of projects also that actually talk about the GPP benefits or impact monitoring on things. So thanks a lot for this.
yeah, okay.
Are there any further questions? That does not seem to be the case. So basically, then I would like to thank you again, Abby, for having joined us with this webinar, and all for you for your attendance.
Sorry, Philip, I'm losing the sound.
You are losing the sound. Maybe just a second, please. Okay, so I try again. Thanks for all of you for having joined this webinar. And we have, especially to you, Abby, for having given us this broad overview and also being available for questions and answers. We will share this video also with the participants. It has been recorded. And I wish you all a great day and a good start into the week. And thanks for having joined.